That sentence right there? It's illegal, right there in the nursing home contract. The line that says you'll be personally responsible for your mother's bill. The line the admissions director pointed at and said, "Just sign here." They told you it was mandatory. They told you it was just part of the process. So you signed. You were helping. You were trying to get your mother into a bed. Of course you signed. And now a debt collector is calling, saying you owe $43,000. And the dread is physical. But here's what nursing homes didn't tell you. That demand, the one that said you had to promise to pay or they wouldn't admit your mother, federal law says that demand is illegal. Been illegal since 1987. That's the year the Nursing Home Reform Act passed, part of a larger law called OBRA 87. Specifically, 42 U.S.C. Section 1396R. It says a nursing facility cannot require a third-party guarantee of payment as a condition of admission. Cannot, not should not please try to avoid. Cannot. So why is that sentence still in the contract? Why is a collection agency threatening your credit score? Because the system is built on a cheap psychological trick. They know you don't know the law, and they know you're afraid. Okay, let's zoom in on the trick. It's a paperwork trap, and it lives in 2 words: responsible party. That phrase is the engine of this whole mess. In most nursing home admission agreements, they'll slide a form across the table. It asks for a responsible party signature. You see that and think, oh, that's me. I'm the responsible one. I handle my mom's stuff. But in legal language, that label can mean 2 completely different things. And nursing homes love to blur them together. On one side, you have an agent. That's someone authorized to manage the resident's money. You hold a power of attorney. You can write checks from her account. You can talk to her insurance company. You're a helper. You are not reaching into your own pocket. You're just routing her money to her bills. The legal shield is simple. Using someone else's money doesn't make that debt yours. On the other side, you have a guarantor. That's a cosigner, a personal payer, someone who promises with their own assets to cover the bill if the resident can't. A guarantor is a backup wallet. That's what the federal law says they can't force you to be. But the contract often uses responsible party to mean both. Agent and guarantor. Same line, same signature box. You think you're signing as an agent. They hope the debt collector can later argue you signed as a guarantor. It's a semantic mousetrap. Bait it with responsibility, catch you with liability. And here's the truly cynical part. Debt collectors know the difference. Or they should. The Consumer Financial Protection Bureau has explicitly warned them. The Federal Trade Commission has taken action. They know that demanding payment from a family member who merely signed as an agent violates the Fair Debt Collection Practices Act. But they also know most people will panic. They'll send a scary letter. They'll threaten a lawsuit. And many families will drain a savings account just to make the calls stop. Congratulations, you just paid a debt you didn't legally owe. Now, let's add a second smaller trap, because the law is never just one clean wall. There is a situation where you could be on the hook. And I need to tell you about it, or I'm just another guy on the internet giving bad advice. If, after the resident is already admitted, you voluntarily sign a separate, clear agreement to be personally liable, and it's genuinely not a condition of continued stay, that might stick. Emphasis on voluntarily. Not sign this or your mom gets discharged. Not sign this or we'll delay her medication review. A true, free, separate choice. Those agreements are rare. And in court, the burden is on the facility to prove it was voluntary. That's a hard thing to prove when the contract is presented by the same person who controls your mother's mattress and meals. Then there are state filial responsibility laws. About 29 states have them on the books. They say adult children can be held liable for a parent's necessary care. It sounds terrifying, but here's the twist. Those laws are almost never enforced by nursing homes directly. They're typically used by state agencies seeking reimbursement for public assistance. And critically, a state filial law does not override the federal ban. A nursing home cannot use a dusty state statute to justify what federal law explicitly forbids. The rare cases that make the news often involve unusual circumstances. It's a state welfare agency trying a Hail Mary in court. That's not your situation. So set that fear aside. It's mostly a boogeyman. So what do you do if the collection letter is already on your kitchen table? First, do not ignore it. Ignoring a debt claim can lead to a default judgment, even if the claim is bogus. You have to engage. But you engage with a very specific tool, a dispute and validation letter. Write to the collector. Demand they provide proof that you personally guaranteed the debt. Ask for the specific contract clause where you allegedly assumed personal liability. Ask for documentation showing you were not acting solely as the resident's agent. Send this letter within 30 days of their first contact. Under federal law, they have to stop collection until they provide that validation. Most of the time, they can't produce it because the contract language was illegal from the start. Second, know the red flags before you ever sign. When you're sitting in that admissions office, ignore the coffee and the soothing brochures. Look at the signature block. If you see the words personal guarantee, cosigner, financial responsibility, or individually and personally liable, put the pen down. If they tell you the signature is mandatory for admission and the clause asks you to be personally responsible, they've just broken federal law. You can cross it out. You can write signed as agent only, no personal liability. You can record the conversation on your phone if your state allows one-party consent. You can make them very uncomfortable because the law is on your side. Third, if you're already being sued, raise the federal prohibition. 42 U.S. Code 1396R is your statutory shield. Mention it to the judge. Mention it in your written response. Hire a legal aid attorney if you can. Many legal aid offices have entire practices dedicated to this exact scam. Let's zoom out one final time. The whole mess is built on a simple asymmetry of fear. They have a boilerplate contract and a collections department. You have a sick parent and a knot in your stomach. They bet you'll crack, they bet you'll pay, and for decades, that bet paid off. But it doesn't have to. The law hasn't been a secret since 1987. It's just been buried under fine print and filial panic. Now you've seen the machinery. A nursing home admission contract is not a mortgage or a personal loan application. It's a service agreement between a facility and a resident. Your signature should be a conduit for her money, not a tap into yours. Helper, not guarantor. Agent, not backup wallet. So check that paperwork. Find the responsible party clause. And remember, the nursing home debt your family may not owe, it's probably most of it.